In furtherance of that right to affirmative defense, here's an example of a quasi-criminal case order specific to a circumstance where you're coming in without an attorney and they've attempted to impose an attorney on you, and you knowing very well that an attorney belongs to the British accredited registry. The judges are also members of the British accreditation registry. They all have lawyer number, they all have international standard lawyer numbers also. Granted, it would be wise for you to put that on the record as conflict of interest, as evidence of conflict of interest. So you then take the order. It doesn't have to be specific to, them imposing attorneys on you, but this is just an example of an instance. What they will usually do if they've tried to impose attorneys and solicit business on, behalf of their corporate interest, if it doesn't work, they will try to do something called pro se admonishment. Admonishment means to just give a formal warning of what they usually would not tell you, because it's just a scare tactic for them saying, hey, don't enforce your substantive right, or else. Well, usually nothing will happen unless you allow this to just linger on. Once they get comfortable doing this, they start bringing meritless claims like contempt of court. So take whatever the order is, whatever the instant matters, take the order, rebut it on its face, and even better, create a separate affidavit called a writ of error, a notice of objection to whatever it is, entered by whatever the name of the acting judge is, and whatever date it is. In this specific instance, this judge is acting as a witness because the matter that gave rise to this order, dated October 6, 2020, was regarding the imposition of attorneys or solicitation of business. So the judge has to be a neutral party. If at that point the judge constantly imposes an attorney on you or solicits business on behalf of his fellow bar members, then clearly he's making it obvious that the capacity that he's functioning is not as a judge. What other capacity can he possibly function in? Because he's not the plaintiff, you're the defendant, and he's acting as the witness. Just saying, hey, you need an attorney. Is this order the 6th of October? Don't hesitate. Say things exactly the way they are. Present things exactly the way they are. And if there are other state attorneys involved in the matter, because what they like doing is once they see that you're not going along with their charades, they will start switching the state attorneys. So name all of them, including the clerk of court, because it's all a concert, a very intelligent and careful concert that they're all in. Make it very simple and make it very clear that you are bringing it to their attention that there's an error on the record, and that your objection, and that you are objecting to the same error. Attach judicial notices of the rules of evidence that pretty much states that the judge cannot be a witness to his own cause. In your state, it might not be the Supreme Court that issues rules of evidence, but in Illinois, it's the Supreme Court that issues the rules of evidence. Put that exhibit in as evidence. Put the Constitution in. So, taking a look at your state constitution, when they attempt to impose attorneys on you and punish you for it, basically, speak up at a very early stage of the proceedings. Do not let it linger on. Do not make them comfortable in it. The affirmative defense or offense, really, are very simple. Principles of due process based on your right to counsel and your right to obtain remedies without having to purchase it, without having to associate yourself. In this instant, with the British Accreditation Registry. Non-criminal prosecution, the accused shall have the right to appear and defend in person, by counsel, to demand the nature of the cause of accusation, to have a copy thereof, to meet the witness face to face, and to have process to compel the attendance of witness in his behalf. A speedy and public trial by an impartial jury in the county or district in which the offense is alleged to have been committed. Key part here is his first clause. If you choose to have a counsel, you can. If not, that's fine. You can present your own cause. And if you want to have a counsel, you still have the substantive rights to choose it without being admonished for it, without being reprimanded for it. And that is based on the fact that no person shall be deprived of life, liberty, and property without due process of law. The moment they try to impose an attorney on you, and if you can prove that that judge is a lawyer, and the other party they're trying to impose on you is also a lawyer, that's a violation of your due process because of the right of association. They're trying to compel you to be part of an organization in order to get the remedies in court. And in some cases, you'll be surprised they want you to hire one and compensate them. According to the 1870 Illinois Constitution, every person ought to find a certain remedy in the law for injuries and wrongs which he may receive in his person, property, or reputation. He ought to obtain by law, right, and justice freely without being obliged to purchase it, completely without denial, aka without admonishment of your enforcement of your rights, promptly and without delay. So the acting judges will try to scare you. They will try to put orders in to make it look as though, hey, you should not speak up for yourself. You should not stand up for yourself. You should not even enforce this Constitution. What are you talking about? Don't try to prove anything to them. Object that order. But before you object it, understand that when they try to admonish you as a quote-unquote pro se litigant, this is what that means. According to Bouvier's, admonition, aka pro se admonishment, a reprimand from a judge to a person accused on being discharged, warning him of the consequences of his conduct and intimating to him that should he be guilty of the same fault for which he has been admonished, he will be punished with great severity. So as we've seen that order, it says pro se admonishment, basically saying, hey, if you're trying to present yourself, we're reprimanding you from it, and you will be severely punished for it. That is contrary to what the state constitution, which they swear oaths to, says. So while you're at it, while you're objecting to that order and placing his oath on the record, a copy of it on its face on all four corners. So get a copy of it and literally put that into evidence. While you're at that, you might as well just take his lawyer credential and that other lawyer who is trying to impose on you, take that other lawyer's credential, put them side by side, put that into evidence also. While you're also at it, report him to the Judiciary Board. They call it different things in different states, but in Illinois, the Judiciary Board. What is the purpose of you reporting him to the Judiciary Board? Conflict of interest, solicitation of business, trespass of your constitutional right. Make it very clear. And then take those orders as evidence. Take those lawyer credentials as evidence. Attach it to the complaint. Now, the Judiciary Board, they do not make decisions regarding the case itself, but they do keep records. These judges really don't like each other. Yes, they're all buddies behind closed doors, but they don't like each other. When it's time for re-election, those little records can be used against them, either by their own fellow judges or by the general public. But the trick to that is this: